So Nancy, what is the role of the Office of Inspector General and what authorities does it have?
The Office of Inspector General was established in 1976, and we are an independent office within HHS that's responsible for providing oversight to all the agencies and programs within HHS and also reporting to the Secretary and Congress. We're a workforce of 1,300 auditors, investigators, and attorneys. Because of our funding mandate, our principal focus is HHS's two largest programs, that's Medicare and Medicaid, and as you know, both programs are administered by CMS. We are legal counsel to the OIG, and our stated mission is to fight fraud, waste, and abuse. We do that by prosecuting civil healthcare fraud and partnering with the Department of Justice, local AUSAs in the regions, FBI, MFUCUs, as we'll talk about later, local AG offices, and other agencies that are tasked with fighting healthcare fraud.
So what types of cases do you work on?
I work on a number of different cases. The primary goal of the OIG is, again, the fraud, waste, and abuse. So the way that we get our cases is through a lot of False Claims Act cases and what we call civil monetary penalty cases. So those are cases, FCA cases are where a relator is involved and they've filed suit, the government becomes involved. Civil monetary penalty cases are cases that my office brings independently on its own. And all of them relate to hospital cases, physician cases, and sort of run a pretty broad gamut.
All right. What tools does OIG have at its disposal when looking into fraud and abuse?
One of the tools that I find the most fascinating and probably the most important now is our access to data, which has changed dramatically in recent years. In the past, if we got wind of a potential issue at, say, a provider's office, we would have to go to a contractor to get information, maybe a subpoena, and as you can imagine, that takes some time. Mm-hmm. Now, really at the click of a button on my computer, I can find out really important data about a provider. I can find out the source of referrals. I can find out how much money the provider has been paid in a period of time. I can find out if there are any audits going on to that provider. That's something that has really dramatically changed as one of our tools. Mm-hmm. We still have our standard tools, which are relators that file these FCA complaints. We also have the Office of Inspector General's healthcare fraud line, the 800 number, the hotline, where we actually surprisingly receive a lot of complaints that end up being investigated by us. We also get sometimes referrals from our contractors, and we really actually get a lot of our agents get a lot of calls from employees who work in providers' offices and are seeing potential issues and they want to tell the government about it. Mm-hmm.
What is the driving force behind the continued focus on healthcare fraud and prosecutions?
Well, the biggest driving force is the money, I'll be frank. Just because we're talking about home health today, since 2010, in the home health category alone, we've recovered over $1 billion in money that was attributed to fraud. So if you can think about the impact of that on the Medicare system and on our taxpayers as a whole, we as the OIG are really concerned about. That's just one area. So our focus is really trying to make sure that the program isn't bankrupted by people who either don't know what they're doing or their intention is to defraud the program. Yeah.
Earlier, just a little bit ago, you had mentioned that you work with the FBI. Is there any other collaboration between federal agencies when investigating healthcare fraud and abuse?
Yes, we work with the FBI, as you stated. We also work with our own Office of Investigations. We have agents that are on the ground in every state in the country. So we work very carefully with them. I feel like sometimes we're sort of a hotline for them. Mm-hmm. They keep us plugged in on their cell phone and they call if they see something or hear about something. We also partner, as you know, tightly with the Department of Justice. Sometimes what happens with Department of Justice cases, they may have a matter, it starts as an investigation into one particular area, and let's say they hear about a kickback claim that's involved in that particular area. Kickbacks are something that we have expertise in. They will forward that to us. So we get calls from local AUSAs, from Maine justice attorneys, and that partnership leads us to, this great number of cases that we bring every year.
Mm-hmm. So at the same time, there are some audits being conducted by Medicare contractors in the field. Do any of those ever result in referrals to OIG for further investigation?
They do. I want to be careful to distinguish that there are a number of different contractors and that our contractors are regionally based around the country. They're different companies that are part of their business scheme. And so the way that we receive sort of referrals from them differs greatly, and it's pretty much on a case-by-case basis. But I can tell you personally that I have on my desk a number of cases that we are investigating that came from referrals from contractors. Typically, contractors are more in the business of identifying what they would call overpayments. When they see an indicia of fraud, that is when they call us and they say, hey, we looked into this particular area. We thought it was just sort of a standard documentation issue. We did a little investigating. We see that it's maybe a little bit more than that. Do you want to take this case? So we have a good relationship with them in terms of receiving those referrals from them.
How does OIG typically learn about potential compliance problems at organizations?
Probably the thing people don't want to hear, your own employees. They find out about the hotline. Google is really easy to figure out who to call when there's a problem. So we often hear from your own employees, former employees and current employees. Of course, we find out about cases through relators when they file a key TAM, and we are allowed to access all of their sources of information. A lot of times our agents will hear about something in an investigation. They may talk to an individual and they say, hey, you should really be looking into this doctor, they're doing this, or this agency is doing that, you should look into it. But I have to say that probably the broadest area that we receive complaints from would be employees, former and current.
Interesting. What are some of the common risk areas that you see home health and hospice providers getting tripped up by?
I think for hospice providers, the issue, and this is noted in the work plan for 2015, hospice providers are running into trouble as they have in the past with the length of stay. Hospice is considered a palliative care function, so it's not something that you would expect to go on for an exceedingly long time. We are seeing really literally across the board lengths of stay that are probably too long for individuals that are receiving this type of care. And as you may know, hospice care is pretty heavily reimbursed, so it's again an area of vulnerability for the federal health care programs. So that's one area. Documentation, which it covers every single category of healthcare fraud. Documentation in the same area, because as you know, for hospice services, you have to recertify that an individual needs the hospice service over a period of time. A doctor is supposed to review the plan of care. We often see issues with that, where the hospice care has been certified and recertified, but a physician wasn't contacted, or there's no documentation suggesting a physician was contacted. Home health is a little bit tied into that, because we know now that, of course, people could be at home receiving hospice care as well. Home health's area of risks are a little bit different. I would say the chief area of risk right now is the referral sources. We have rules and regulations that mean that individuals cannot go to a particular physician and say, I will pay you this much money if you refer all of your business to this particular healthcare entity, this particular home health entity. That's probably the largest area that we've seen a spike in issues. And I think that along the same lines, home health agencies are not necessarily doing a great job with their documentation, meeting the documentation requirements. It may be because they don't know what they are, or it may be because they're just unaware of what they are supposed to do. But all the same, when we go in and we do audits or we subpoena documents, we're seeing often people who are getting home health services. They're not certified to get home health. They haven't been seen by a physician. They're not meeting all the requirements, and that causes an issue for Medicare.
That sort of leads into my next question. I'm sure a lot of the people in attendance know that OIG recently released its work plan for fiscal year 2015. Can you speak to what it plans to focus on in the coming year for both home health and hospice organizations?
Sure. For hospice, it's definitely the length of stay and the documentation, like I talked about, and reviewing. I think you'll see undoubtedly more audit work in that area. And just a lot of discussion about what's going on in that area, because that's been identified as a hotbed of fraud. For home health, again, a little different. Two of the areas that are identified in the work plan that I think are really important are, one, the interest in the criminal sanctions that some of the home health employees have received. This is a big area, and when we talk about risk areas for home health, this is also a very large risk area. Home health agencies typically employ a lot of nurses. Unfortunately, a number of nurses in our country have been excluded, and they're on the list of excluded individuals, which we call the LEIE. So the criminal sanction piece is linked to this, because if a nurse has been criminally sanctioned, they typically are also on the LEIE. So I would think that if in the work plan we've talked about the investigation of criminally sanctioned individuals, our agency is probably going to see a lot of referrals of those cases where somebody has been excluded and they are working still for a home health agency, which is in violation of the rules. And I'll just note here why this is, again, really important. If you employ an individual who's been excluded, the federal health care programs will not pay for their services. They will not pay for their services. So you can come up with every reason why you didn't catch that person wasn't on the LEIE. At the end of the day, it doesn't matter. You're still going to have to make it a minimum and overpayment, maybe more, to the federal government if you identify a person or we identify a person that's on that list. The second category is, again, the same thing that touches every category, and that's billing and documentation, where we just see a number of what some people would categorize as errors, what we would sometimes categorize as deliberate ignorance, or somewhere in between, and sometimes straight fraud. But the billing and documentation in the criminal sanctions area for home health are big in the work plan, and you will see a lot more of that in the year to come.
So you had mentioned some common risk areas, and then talked a little bit about the work plan. Have you noticed any trends or problem areas for home health and hospice agencies where they get tripped up, or something they should be aware of?
I think for home health, the referral sources, I have at least 5 cases on my desk now, literally, that all go back to referral sources. As you may have seen, our agency has settled a couple of cases in the last 6 to 12 months, one of which was a case where 7 different physicians' wives were actually prosecuted by our office because they were hired by home health agencies at $60,000 to $75,000 a year, and all they did was refer business, make sure the business was referred to a particular home health agency, in violation of the law, and obviously something that these individuals should not have been doing. That was more than a $2 million settlement, so a lot of money. I think that the issue is that there's a thought that it's competitive out there, and you're trying to get business from, obviously, different providers. You're certainly able to do that, but you have to do it within the confines of the law. You can't pay people for their referrals. You cannot pay people for referrals. I can't say it enough. That's an area that I see, especially in coming years, because of, again, what I talked about earlier, the availability of the data. When one of these cases came across my desk, I was literally able to ask an agent for some help. By the end of the day, I'd heard about this physician who apparently was getting paid a lot of money to refer a ton of his business to a particular home health agency. Click of a finger, by the end of the day, I had all the data which said that 100% of his referrals were going to one home health agency. Wow. Pretty suspicious.
Yeah,
so. Definitely.
So you've just started to give us some real-life examples of illustrating how home health and hospice agencies get in trouble. Are there any others?
One big one to look to is a settlement that we had with Amedisys, which happened in April of 2014. That was a $150 million settlement and a CIA. The CIA is important because it's got enhanced provisions. It doesn't look like our other CIAs. It's definitely in a different category. That case covered a number of different issues. There were documentation issues, need issues where bennies were admitted into home health services but really didn't need them, and medical necessity across the board, and then just generally upcoded claims. So it was a little bit of a hodgepodge of areas that were admitted to in this case, or alleged, I should say, in this case. But I think that they are pretty representative of probably what's going on in a number of home health agencies. So that's one that I would look to. I would also look to some of the cases that we have that I spoke about that have to do with the referral sources, which there are some of those cases settling now, and you'll see more about that undoubtedly on our website next year.
Got it. In your opinion, what are critical aspects that providers should try to incorporate in their compliance programs to avoid some of the things you've just talked about?
There are a couple of things that are really important in putting together a compliance program, and a program that really works. I monitor CIA's corporate integrity agreements with providers across the country, so I'm lucky enough to actually go in-house to different providers and see what's going on and sort of see for myself where their areas of risk are, even after they've undertaken a CIA with our office. I would say the chief issue in establishing a compliance program is really establishing the culture of compliance. We talk about that, but often people are missing what that really means. The reason the culture of compliance is so important is that if you are employing a number of different people, nurses, whoever your employees are, and they don't feel like they can go to anybody who's on a corporate level within a business and tell them what's going on, they will call me. And I don't think you want them to call me. They'll call me, they'll call the government because they're upset about what they see going on. Those are your boots on the ground. So you may be in an office thinking we have all these policies and procedures and we tell people not to do X, Y, and Z. But in reality, those boots on the ground know that that's what's happening. So establishing a really strong compliance officer, somebody who's skilled and knows what compliance means, not just a title, but actually attends training and knows what compliance takes, to sort of set that wheel in motion and let people know, I'm the person, go around and introduce yourself to everybody. I'm the person you should come to. If you see an issue, you should feel like you can come to me about it, and I will do my best to try to fix things or investigate and see what's going on. That's the first step that I see. That compliance officer should also be somebody who, if they don't know, they need to hire somebody who knows how to audit. Auditing is a key aspect of this because, like I said, when you're in an office, you can often think you know what's going on, and once you get the government subpoena that says, hey, you've been overbilling in this particular category, or no, you don't have the right documentation, and you're surprised about it, it's something you could have caught in an audit, and you typically will. Auditing is something that should be really going on a monthly basis to be at your safest, and you should be auditing different categories of your business, not just one, because problems occur across the board. I'll tell you that when I visit various organizations monitoring CIAs, they often sort of cry their first year because they're required to sign this deal with an IRO, an independent review organization, who reviews their claims. So it's their big audit process. They are sometimes shocked to see what actually was uncovered in an audit, where they thought, oh, I thought we were doing this correctly. But if you can afford to get an independent auditor, but you can do lots of great in-house auditing as well. So that's another piece of it. And then the education piece of it, arming your employees and your staff with, again, that corporate compliance structure, letting them know when there are issues that they can actually come and talk to a person who's on the ground who will respond to them. I think if you take steps like that to create a different culture of compliance, it really helps the organization. The OIG also has some compliance guidance on our website that is fundamental but very helpful that you can avail yourself of, that's on the OIG's internet site. And you'll see a link to what are called compliance CPGs, and they set out a little bit more detail about the auditing function, the compliance officer function. But I think if you start with those, you can get yourself in a position to say you know better what's going on with your organization in terms of whether they're compliant or not, and what you can work on in the future. And of course, there's always if you undertake to audit and find out all this information, and you find out, oh, we're making some errors in a particular area, availing yourself of what the OIG has, what I think is a fantastic program, that's the self-disclosure protocol. That's your mea culpa, where you get to call the government and say, I think we made a mistake in this area. You have to abide by certain rules to be admitted into the self-disclosure protocol, but it's a great program because it's your one opportunity that you're able to tell the government, I did something wrong, we think we did something wrong, here's the value of what we did wrong, and enter into an honest conversation with the government about it, and then end up, hopefully, if you stay in the protocol and do what you're supposed to do as a provider, you end up more than likely not having to sign a corporate integrity agreement, and also having more flexibility in terms of the damages. It's typically not a triples damage multiplier that's applied through the self-disclosure protocol, because we're giving you credit for coming and telling us. You're saving us money. If we don't have to go and investigate and you do the work for us, we will give you credit for that. So that's hugely important.
Got it. It's good to know. So the ongoing auditing, training, which you just mentioned, are there any other actions that home health providers could take? Or
I think checking the LEIE, as I talked about, goes without saying, but it's something that I find a lot of home health providers feel like they know their nursing staff and they think, none of these people were on the LEIE, they didn't do anything wrong, or at least they think, I would have known if they did something wrong. Here's the problem. Sometimes individuals are excluded and they don't realize that they've been excluded. And you wouldn't necessarily, as the provider, know that they've been excluded either unless you're checking that list. That list is updated on a monthly basis, so I encourage that providers check every month. You'd be shocked. There have been people who have not known for 15 years that they have been excluded. And just a note, another reason why that's a little bit more complicated, reinstatement after exclusion is not automatic. So there's sometimes an individual that you could be employing who's been excluded, thought that the duration of their 5-year exclusion had passed, and didn't realize that they were still on that excluded list. And like I said before, there's a lot of money at stake, because all the money that you've billed the federal health care programs, you will have to repay all of that money. I have several settlements now that are upwards of $1 million for individuals that were excluded for more than 5 years.
And where is that list available?
The LEI is actually on our OIG internet page, and it has a searchable, downloadable feature, which is great because you can download the information and compare the list among all of your employees. And you also can enter employees' names, I think 6 at a time. There's some companies that choose to go to outside entities to do their LEIE searches on a monthly basis. That's a business decision to be made. I would just be certain that whoever you task with doing that they're actually doing it on a monthly basis and that they are really checking the names on that site.
Great. So I think at this time we're going to open it up to the audience for questions. Just a reminder if you have questions for Nancy, simply type the question in the chat box so that it's included in today's recording. Let me check the first question here. I think the first question was actually where to find the list of...
Oh, the LEI?
Yes.
Yeah.
So let me pull it back up here. If a physician believes a particular agency provides better service, makes a referral process easy, why not send all of your referrals to one agency?
That's a great question. And I think something that our office deals with when we're actually looking at the referral sources, because of course we hear this too. I think the issue is that typically in most locations, just because of the competitive nature of the business, there's probably more than one agency that provides stellar service. That said, if you are referring business to one entity, but you're not receiving any payments or any favors or anything, there's no remuneration going between the individuals. You just refer because that's who you love. I think that that's maybe a defensible position. I will tell you that if you are referring 100% of your patients to one place, you're probably going to pop up on our screen and we're going to want to know why you're doing it. If you can defend that position and say it's just because of the level of care, and understand that begs the next question, which is there aren't really any other agencies that you can refer home health agency business to. And really the backdrop of this is that the federal healthcare programs are concerned that the color of that money is what impacts people's decisions sometimes. So what we would prefer to see is a physician saying, well, there are a number of different agencies that I can send this business to, as opposed to there's only one, and maybe this one gives me special treatment, gives me some remuneration, whatever is going on. So it's not that it can't happen, it's just that in most situations that I've seen, there are a number of other entities that the business could be referred to, and it looks suspicious if one business is getting all of a physician's business for home health.
Got it. And sort of along the same line, we do have a question regarding a physician owning a hospice agency. Is that possible? Provide some clarification.
I think I'm ever the lawyer. It's a fact-specific question, because is it a retired physician? Is it a physician who's actually treating patients? Are they referring services to themselves? That's really where the problem comes, right? Because if they're a physician and they have their own patients and they're referring those patients to a business that they own, then there is potentially a problem. Can it be avoided? There's certainly physicians that have ownership in lots of different entities and they just avoid any referrals to that business that they also own. But that is it's a slippery slope.
There's a question asking if we can address the areas of concern with marketing.
I'm not sure what the specific question is, but I think I'm guessing it's that there are individuals who are out there that are coming to a particular senior center and having a pizza dinner and saying, this home health agency provides these services. I think that if you read very carefully what the Stark and Kickback rules are and what they say, there are limits, monetary limits set every year by which an individual can sort of come into a community and say, here, come to our business. We want your business for this reason, in addition to a physician's office. As you know, there are reps that come in physician's office all the time from drug companies from everywhere saying, we want your business. Well, we've set pretty strict standards about their conduct. So that means that they can drop off a pen and they can drop off a pizza for the whole office, but If it gets above that number, which I believe, don't quote me on this, is 373, it starts to become an issue. So when it comes to marketing, I think you want to be careful in terms of how much money is put into marketing. And by that I mean going to the individual home health agency or going to a physician. And I think you want to be careful about what's being promised in that. If it's more than, if it's, going to really expensive sporting events, et cetera, it can start to become questionable what kind of marketing technique you're using.
Got it. So aside from length of stay, are there any other hot topics that our audience should be looking at when in regards to hospice?
I think the general billing, that we see a number of problems with the billing in that people are receiving hospice care, but there are levels of hospice care. Sometimes people are being billed at the top level of hospice care for their entire duration, which could make sense in certain areas, but not so much in other areas. And again, if the documentation doesn't suggest that the patient's condition stayed the same or got progressively worse, you're going to have issues with that. So those are really the two big areas.
Okay. What is your suggestion for getting referrals without being fraudulent? What are some of the things that providers can include in conversation with discharge planners, social workers, or physicians?
I think that again, the ability to conduct your business hasn't changed. You can certainly go and visit all of these individuals and say, we provide fantastic service. This is the kind of service that we provide. These are the kinds of nurses that we provide. We have the most up-to-date technology. This is what we do that's different from maybe any other home health agency. Where you start running into problems is the example I gave, which is pretty dramatic, of, oh, does your wife not have a job? She's retired. Here, I'll pay her $70,000 as long as she sends business to me. That's a problem. Oh, I'm going to take you to all the Knicks games and you can sit in my box as long as you refer business to me. Those are very obvious problems. There's some less obvious problems sometimes that you can get into. I think that the surest course is to make sure that when you are marketing your business and you're trying to get business from an individual, that you're careful in terms of what you promise. Sometimes, let's be frank, there's a little bit of a shakedown because the physician may say, what are you going to do for me if I'm giving you business? I would run from that physician because that's just a scary place to start. But I think if you're not promising remuneration for what you're doing and you're just extolling the virtues of your business and saying how great they are, and hopefully they are, then that's really your best way to get business. That's the legal way to get business.
So what is OIG's stance on hospitals with their own home health agency or hospitals who have entered into an agreement with a particular HHA, forcing patients and hospital staff to utilize said agency and communicating to outside skilled nursing facilities that they will not refer to them if they do not use their home health agency?
I don't know that I can say what OIG's stance is on that so generally, but I will say that if you, as an individual or as an owner of a business, feel like something is going on that is cutting into the way that you're able to conduct your business and you think there's something illicit or strange about it, call that hotline, call us, report it. Maybe you need to talk to an attorney and actually find out whether this is something that's worthy of filing a qui tam over. I can't say what our position is because it depends on so many other factors. There are certainly times when hospitals have rationales for doing what they do. Without knowing a ton of facts, I'm hesitant to say what our general position is, but I will say that if we get a credible complaint or get word of something going on that seems problematic, we will investigate it.
So we have a question regarding ACOs. Are they an exception to the rule on referring between entities? It sounds like some people are running into a scenario quite a bit where hospitals refer to their own home health agency because they're all under the same ACO.
I don't really know if I'm in a position to comment on the ACO piece of that.
Got it. Let's see here. The intent of home health face-to-face was to reduce fraud. Has that been effective in reducing fraud, have you found?
I'm not sure that we have been able to mine the data enough to know. I think we have the same question, and I don't know that enough time has gone by for us to compare, because that's really where we get our comparative data, is where you get the most information, because you're looking back and saying, okay, this rule was in place in 2010, it changed in 2011, and claims dramatically dropped off. And then you'd be able to say, okay, this is working. I don't know if we're early enough or what the data mining has been so far. We haven't gotten any word about it. Obviously, that was our intent. We don't know whether that has actually been effective yet or not, but I would think, at least in what I've seen in terms of my cases, I sense that it has helped. But to the degree, I don't know about that.
Okay. How often does OIG look at the practices of very small hospices? Is there a difference between how you handle larger hospices and smaller hospices? Do they tend to fly under the radar a bit more, or?
I would say they could fly under the radar. Again, the data mining has changed all of that, because when you data mine and you're looking for, say, the company that's their home health agency or hospice that's billing, say, let's take long-term stays. Who's billing the longest of these length of stays, right? Then whoever's billing the longest period of time is going to come up in that data search, as opposed to let's look at the top 10 hospice providers and see what's going on there. So I would say that is something that is changing dramatically, and we're seeing that in my office, which has evolved into my office doing a banner number of civil monetary penalty cases where we find from our data that kind of information and bring our own enforcement action, which doesn't involve the Department of Justice. My thought is that there probably is a difference in terms of when you say flying under the radar, that maybe in the past you could have flown under the radar. I'm not so sure now that you can, with this data mining, I think you really can't do that anymore.
Let's see here. Can a hospital have a preferred hospice provider?
Depends on what you mean by preferred.
That
I think if you say preferred, for what reason, how long has this preferential treatment been going on? Does the preferential treatment mean that they're getting 100% of the referrals, or they're getting 10% or 15%? I'll tell you that when you look at the data, what you typically see for any physicians that are referring business, you'll see sort of a breakdown of a number of providers that they're referring to. And in different fields, it's different. Obviously, if you're a cardiologist or sort of a family practice physician, you're going to see a difference. But you will see what you normally expect to see is that breakdown. So maybe it's 10% to this home health agency, or 10% to this hospice, 10% to this hospice. And I'm using 10%. That's not the number to be striving for, but that's the number that I'm saying. You'll see this, and you'll see sort of trickle downs and ups from there. So maybe somebody's getting 2% of the business, someone's getting 18% of the business. It's kind of all over the map. It should sort of look like this. When we get alarmed is when we see just a flat line like this. It's not that you couldn't have a provider that you prefer, but again, going back to my earlier statement, I would find it hard to believe that with the number of agencies that provide home health and hospice services, that there's only one that provides the best services and there's no one else that you could refer to. Okay.
So are you able to speak to OIG's position on long-term care facilities that are now having their own hospices?
Speak to it in what? I guess I need more of a question.
I guess just the position on long-term.
Whether they, I would need more details.
Got it. Let's see here. There are hospitals that own nursing homes and home health agencies. Can that be considered a conflict of interest or questionable?
It could be a conflict of interest for sure if they're, again, looking at the referral sources and where the referrals are going and why they're going there is really the question, because obviously Stark prevents any self-referral. So there are exceptions, and if you meet some exception for a kickback or Stark, then obviously you're permitted to engage in that conduct. But it's definitely a red flag, and something that at a minimum you need to get legal advice about how that will work in terms of the referrals.
Okay. Let's see. Does OIG plan on focusing on Part B providers set up in assisted living facilities and oftentimes providing free screening to increase referrals?
Yes, in fact, that's something that I have seen come across my own radar recently. I don't know that OIG has stated that we are, there's no task force that I know emerging on that particular issue, but we are seeing more of that, and that is something that an area that we're interested in.
Here's a question. It has been brought to our attention that other agencies go door to door to solicit their services. Is that allowed?
I believe if they're going door to door and leaving a flyer or talking to particular bennies, I believe that they are permitted to do that. I would question whether that's all they're doing. If they're doing a little bit more than that, something that I didn't talk about earlier when we were sort of talking about some of these things, is that we see also issues where bennies are paid off by home health agencies to actually go with a particular home health agency. That's why I'm saying that. If they're just going and saying, here's accurate home health care, if you ever need home health assistance, talk to us, here's our number, you're certainly permitted to do that. But if you're going door to door, which I see more of, and saying you should come to Accurate Home Care, you don't need home health services, but if you give me your number, your Medicare number, I'll give you $50 and you can go to the casino, or we'll give you a ride to the casino, or other nefarious, believe me, there are lots of schemes to get bennies induced to give their Medicare number to home health agencies so that they can bill them. I would question whether they're doing more than that, and that's something that you only know from, of course, talking to the bennies. So.
Got it. Here's a question. Do you know of any, or are there any best practices for remuneration of independent home health marketers?
I don't know offhand, but I believe that there are, on our website, there's something that relates to the sort of these best practices. And I can't quote any of that, but I believe that that's on our website under the home health section.
Okay. If a skilled nursing facility utilizes a home health agency or a hospice agency owned by the parent company of a SNF, is that allowable?
Repeat that one more time.
Sorry.
It's okay.
So if a skilled nursing facility utilizes a home health agency or a hospice agency that are both owned by the parent company of the SNF, is that allowed?
Again, red flags, but I think it depends on what the actual legal ownership looks like, what that structure looks like, because that could qualify as a self-referral. I think that it probably is, but I'm not positive about that. Again, based on different facts that we would need to know about the legal entities themselves, that could potentially be an issue, yes.
This kind of sort of goes along in the same vein and keeps in the trend of the hospice questions, or the hospital questions we've been getting. Can a hospital system require its physicians to refer their patients to that system's hospice exclusively?
No, I think that that's one of the scenarios I'm talking about. And again, think back to what I said about OIG and what our role is. Our goal is to make sure that beneficiaries are actually getting the best services. If a hospital is saying you doctors can only refer to this particular home health agency owned by them or not, there's a question about whether that home health agency or hospice is actually providing the best services, and we're concerned about that. That would raise a pretty big red flag for me.
What length of stay is OIG looking at?
I don't know that I can comment on what the length of stay is. I think that there are different metrics used to get that information and to get that data, so you can look at it in a number of different ways. I don't know that I'm able to say what that particular length of stay is, that if I said 7 days, everyone would be flipping out about the 7-day mark. I'm not sure what that number is.
Here's a question. When physicians merge with a hospital who also owns their own home health agency, why are they only allowed to refer patients to the hospital's home health agency? What about patients' rights to choose? Should that not come first?
I think the patient's right to choose comes first always. It trumps everything. Again, that sounds like a red flag. And remember that a lot of times this kind of conduct, if it's going on, I mean, you guys are asking great questions. If this is what's going on, and I'm a little frightened to hear this, but if it's what's going on, you should absolutely be reporting this, because I know that this impacts the bottom line of every home health agency and every hospice agency. If you're cut out of business because of some illicit practice, the government, people who care about this can't do anything about it if we don't know about it. And remember, this isn't something, these areas, we do all these audits, we look through all this data. Things like a home health agency going door to door and telling bennies we'll send you to the casino, we have no way of knowing about that unless we don't follow the marketers from door to door to find out what they're doing. We only would know about that if you tell us about it. So we are open to getting information from you. The hotline is probably your best bet. Again, if you think it's, in your judgment, more serious, I would consider talking to an attorney about it and figuring out whether it's something that you need to file a qui tam about.
Do you have any recommendations for hospices structuring palliative care programs so they're not viewed as feeder programs when they're trying simply to meet that very real need?
I think that in the hospice industry, there's a lot of discussion about this, and I'm not sure that there's sort of a one answer that I can give other than I think it's forming in part. I know that OIG is looking at this and hopefully coming out with better guidelines about, you know, palliative care and a lot of these issues. I feel like it's something that the industry has to come to a place to understand really what's best. What they think is best and what we think is best may be different, but I think it's something that the industry itself has to come to. I don't know that the OIG has sort of spoken on that topic to say definitively what the answer is.
If a doctor is the agency medical director, is it okay for all of his or her referrals to come to that agency?
No. Again, that's a phone call for us.
Hmm. Let's see. Can a physician provide a HHC choice letter on a home health care letterhead to a hospital?
Say that again.
Can a physician provide a HHC choice letter on a home health care letterhead to a hospital?
I don't know the answer to that.
Got it. Let's see.
I think it would depend on what the content of that letter. Yeah.
For referrals from hospitals, the hospital conditions of participation requires that the patient be offered choice of home health or SNF as part of the discharge planning process. I guess that was just a statement.
Right.
Yeah. Okay. Let's see. I think we have a few more here. They keep coming in, so. Why are hospitals allowed to own home health agencies? It kind of shatters businesses. It kind of shatters the business for all other home health agencies.
That's a great question too. I think that we live in the United States, and we like to think that we have fairly business-friendly rules and regulations. I think the government doesn't want to be in the position to say a hospital can't own a different segment of the healthcare arena, in part because there's one part of me that would say a hospital is in the best position to tell a home health agency what to do, and they have the relationship because they're the hospital, right? So they're actually in a very good position to potentially have a great home health care agency. That said, they can own one, but if there are requirements like some of the other questions covered where all their physicians have to refer to only one home health care agency and it's the one that they own, it's trumping the patient's ability to choose, and it's flying in the face of what I think are lots of rules that say you can't do that. So although we cannot bar a hospital from engaging in that type of business relationship, I think that the hospital also has to take on the onus of going and getting a legal opinion about what the extent of their interaction can be with that particular home health agency. Because if it exists and it just exists in its own space and physicians that work at the hospital happen to refer there or not, I think that that's okay. But I think that if there's an issue about, required referrals to a particular source, that's when we would get concerned. It's definitely something that would, as a lawyer, would make me nervous hearing that. But I would need to know a little bit more about how nervous to get about it.
Is it acceptable for a home health agency to refer a patient to its own hospice?
I think if it's referring it to its own hospice, but it's referring it to other hospices as well, I think it's okay. I think if you are directing the patient to only, which is sometimes what happens, is that the home health agency will say, we know this great hospice organization. We'll just send over everything to that organization. Well, then you've deprived the patient of the choice, and they may not know that you own that company. So I think it could happen, but it would depend on the context in which it happened.
Okay, here's a question going back to marketing monies that are allowed. Is $373 the number per MD or marketing costs per budget year?
I believe it's per MD, but I would check. Our website has more explicit information about this, but I believe it's per MD. So in a practice, I think, well, actually, I'm not sure. In a practice, it could be attributed to the entire practice, but I believe it's per MD.
Okay. Here's a question. It is a bit confusing that medical directors and facilities cannot refer to their own or preferred hospice, yet ACOs can. Can you speak to this at all?
Again, I don't want to talk too much about the ACO piece of it, so I'm not comfortable answering that.
Why can't the OIG make a site visit once a complaint... Okay, sorry. Why can't the OIG make a site visit once a complaint has been made and warn them that a kickback has been committed?
Well, one, I would be traveling all the time and I wouldn't be here because literally I do think that that's what would happen. We have limited resources. That said, we try to utilize the resources we have to the best of our ability. I don't think that we are in the position to, unfortunately, warn people about the law and trying to stay compliant with the law. That's something that providers, when you sign the provider agreement with Medicare, you certify on there that you are going to learn the law and you're going to stay compliant with the law. So that's in part your job. Our job is, of course, to enforce that. And so I just don't think we have the ability to go out and say to people, hey, it looks like when you told this particular provider you would give them money, that was a kickback. I don't see that as our role, and I'm pretty sure that nobody in the government would agree that that's our role. I think it's the role of the provider to find out what the law is and to try to stay in compliance with that. That said, if you call an attorney, you can get legal advice about what's acceptable and what isn't, and what's legal and what isn't. But I don't really think that that's our role. And even if our office embraced that role, I don't think we would have the money or the time. That is literally all we would do.
Can you speak to some of the violations that can lead to your name landing on the LEIE?
Sure, that's a fantastic question. So there's a long list of sometimes what I have found odd things that end you up on the LEIE. So one area is if you're a provider and you took out a HEAL loan, those are the health education loans, and you default on those loans, you will end up on the LEIE. So there are physicians sometimes who are on the LEIE for that, and either they don't know about it or they know and don't disclose that to their patients. For other providers who are on the LEIE, there's a number of things. The biggest category are the misdemeanors and felonies. Obviously, a felony, I think most people would understand and agree that they can understand how someone could end up on the LEIE for a felony. But what people are not necessarily aware of is that if you commit a misdemeanor in certain areas, you can also end up on the LEIE. I use as an example a case that I handled when I first came to the OIG where there was a nurse who stole 2 oxycodone pills from a nursing home, from a Benny at a nursing home. She had a drug problem, and she ended up taking a plea, which is another issue. She took a plea, and for the purposes of OIG's rule in the statute, once you take a plea, that's considered a conviction. So she had a conviction for this misdemeanor, and I'm blanking on what the misdemeanor was actually termed, but it was considered a healthcare fraud issue. So she ended up actually getting this conviction for stealing these 2 oxycodone pills. She went to rehab. She ended up it wasn't expunged, but she got the conviction. It wasn't reversed, but they did something to it, and it was contingent upon her attending this rehab program. But then at the end of the day, 2 years later, after all of that is over, she got an exclusion notice from us because of this misdemeanor. So there are things like that someone will say, and sometimes quite honestly, I thought if I stole 2 pills and I went to rehab and I remedied the situation with the local prosecutor, why is the federal government telling me that I can't, bill any of the federal health care programs? There are other areas of fraud. Of course, I have more dramatic cases. I had a physician who was part of a pill mill scheme, and the physician was actually put in prison for 15 years. And she was, of course, excluded immediately. Some people think that when you're fighting the conviction itself, and she's, of course, appealing that you come off the excluded list, but you don't. So there's sort of many different areas and things that you could get in trouble for. If anything is deemed healthcare fraud, if that's something that you pled to or you're convicted of, you are almost certainly going to end up on the LEIE.
Good to know. Thank you for building that out. Could you elaborate on the acceptable method of documenting choice of providers? For instance, a home health agency who owns a hospice agency, et cetera.
I think that the documentation that some of the things we'd want to see is that has all been clearly communicated to the individual who's making the choice in the services, that maybe it's a flyer or something like that that has a list of all of the agencies that the particular patient could go to. I don't know that that's, again, it would depend. If you're handing that flyer to somebody but saying to them, we're going to pay you this amount of money if you go with this particular agency, or promising them this trip to the casino, that sort of takes away the fact that you gave them this flyer. But I think that that's a good indication. You should be tracking that you're communicating to patients what their choices are.
Here's a question. Is there an let me start again. Is there an explanation on why the state of New Jersey limits Medicare A certified agencies to a handful in each area that tend to monopolize home health services?
I don't know the answer to that.
What is the true purpose of Zone 7 ZPIC if agencies are fined large sums due to infractions and overpayment, yet they continue to function for years until appeals are settled? Is that not high risk for continued fraud?
Identifying these particular companies. I would say yes, but I would also say that, again, with the ZPICs, they're vastly different. I'm blanking on where Zone 7 is, but they're vastly different in the way that they interact with us. This could be an area where they refer a lot of those cases to us, or they don't. And that's not something that we obviously can control. But that would be my answer, that I'm not sure I know why Zone 7 is doing that. And it may be that the other thing to remember through all of this is that we receive lots of referrals about cases. We are an office that has lost a number of attorneys over the past few years because of budgetary constraints, set upon us by Congress. We are hoping to grow the number of attorneys that we have, but in terms of how many cases we can handle and the complaints that we receive, they're voluminous. And so we sort of have to pick our targets and what we're going to actually investigate and use the limited resources we have, what we're going to use them for. In some cases, there are cases that are brought to our attention and they may be actively investigated right now, and I would know that, but you all wouldn't, and I can't share that with you. So it's not that just because something's not happening to a particular provider right now that they are not under scrutiny by our office or the Department of Justice or anyone else. We don't comment on ongoing investigations, but there are plenty of them. So that's something to think about, that just because there's an entity that appears to be operating by itself in its own vacuum and doing whatever they want to do, I wouldn't set that as your model, and I wouldn't say that they're getting away with anything, because you don't know what's coming down. When they get a subpoena, things change.
Mm-hmm. How long does an individual or entity stay on the LEIE?
Good question. It depends on the length of their exclusion. If by statute, we can exclude people for felonies, for misdemeanors, and a number of other things for 5 years is the sort of threshold. That said, I've had cases like the physician I told you about that went to jail for that long period of time. She's excluded for 50 years. So she's going to be on the LEIE for 50 years. You're on the LEIE, though, until even after the period of exclusion has ended, you don't fall off of the LEIE. We don't police that. You have to apply for reinstatement. We do that because we don't want particular providers who might be on there and are still in trouble at the conclusion of their exclusion period. If we find out that they want to get back in the programs and build the federal healthcare programs, we don't assume that they've learned their lesson, because we've learned a lot of times they haven't. So if somebody says to you, I was excluded 10 years ago for 2 years, I'm sure I'm not on there anymore, I would not believe that for a second, because they could easily still be on there. Unfortunately, a lot of people don't know that they have to actually apply affirmatively for reinstatement. So the period that you show up on the LEI depends on the length of exclusion and whether you've tried to get yourself reinstated.
Does a level 2 background screening have the LEIE information?
I'm not sure what a level 2 background screen is. I'll say that typically when individuals or companies do the criminal background screen and they check a number of different sources, what's on the LEIE won't show up on there. That is an independent search that you have to do. I wouldn't trust any company or anybody else telling you that they do. I know there are a lot of companies that sell themselves on doing these packages of research that they do. Someone could have a criminal conviction and you find out about it, or find out that it didn't show up on their record. But again, depending on the details of their conviction, they could still be on the LEIE.
What can an agency do when the physician tells the patient to leave an agency and go to another where that physician is a medical director?
I think in part it depends on whether they're telling the patient to leave because it's their business, because it's a business that they have this relationship with, or they're telling them because wherever they are, they're not getting great treatment. I think it sort of depends a little bit on that. I certainly think that if that's a trend that's going on, then that's a reason to call me and tell the OIG about it, because that's problematic. But without knowing more facts, I can't say it's totally against the law. There could be a rational reason why the physician's saying that.
What is the disadvantage of being on the LEIE list?
The disadvantage? Well, it's all disadvantageous, to your employment. I think that if you want to continue to have a career in healthcare and you're on the LEIE, it's going to present issues, because potentially anywhere that you seek employment, if they know, the rules, they're going to go check this and find your name on there. I think there are a number of people who are on there who could either get a waiver, which means that they could actually get reinstated because they're in a rural area and they can still provide services. There's reasons why we do these waivers for people. Sometimes people are still on there because they just never affirmatively sought reinstatement. I don't know that there's really, there are tons of disadvantages, but the biggest disadvantage is that it's going to show up and that nobody's going to want to necessarily employ you if they're billing the federal healthcare programs. I will say that if you're billing the federal healthcare programs, it doesn't mean that a person who's been excluded could not take on another role. There are times when we have excluded individuals who do something totally outside of the billing the federal healthcare programs. Like, this is not a great example, but say you were a nurse who was excluded and you end up working as a janitor at a hospital. That isn't something that we would potentially have an issue with. But again, the money that pays your salary can't come from any of your federal health care reimbursement. So, yeah.
It's a bit of a long one, but we'll dive right in. As part of the professional development piece in a hospice's respite and GIP contracts with SNFs, there is an agreement that hospice should provide hospice-related education in support of PT care. However, it is considered to be enticement when hospice is asked and then provides hospice-related education to facilities and communities when they have no current contract or even current PTs in. Wouldn't that count as hospice's responsibility to educate the greater community?
I would argue that it could. I think, again, if you're going about the education process in the right manner, that there's not necessarily a problem with that. Again, marketing your business in a very general way is not something that the OIG or any other government agency is seeking to regulate. But we are trying to make sure that if you're doing it without remuneration, without acting in a manner that individuals, be it bennies or even physicians, feel pressured into actually getting services from you for illicit reasons. So it's not that I don't think that it could happen, but it would have to happen. I just think that the line gets blurred very easily. It could start with, let's have this pizza at lunch for somebody, and it can quickly turn into, and let's give them this, and let's give them that. And when you talk about remuneration, and remember, remuneration is a fairly broad category in terms of gifts, cash, favors, that's all considered potentially remuneration. You can cross that line in the blink of an eye.
So we're redoing our standards to conduct we're redoing our standards of conduct to make them accessible and meaningful to all our diverse staff. Can they be as simple as 1, XYZ Corporation is committed to compliance within the law, 2, we expect our employees, vendors, etc. to comply, and 3, we expect employees to report non-compliance, and 4, we are committed to responding to reports of non-compliance, and then when the details in our compliance policies and procedures?
I think they could be, that's pretty general. It's funny that you asked this because I just actually saw a submission from somebody that's under a CIA about to enter into their annual report phase, and they're implementing their CIA, and they asked the very same question about how much information they needed to give. And I told them, I've seen a number of what these policies look like. I told them that my issue is that the less information you give in your policies and procedures, then the less information the troops on the ground have, and they'll try to figure it out themselves, and trying to figure it out themselves might mean going to a lawyer and filing a qui tam. By telling individuals that work for a company, by telling your employees, we expect you to follow the law, is great, except that they don't really necessarily know. You got a nurse. I'm a lawyer. I don't know really what nurses do. I'm sure that nurses don't really know what I do necessarily. So you're asking them to follow tenets of the law, but they don't necessarily know what they are. One thing that I would suggest after seeing a couple of these submissions recently is giving a little bit more information and saying something. In one that I just saw recently, the provider did a great job of going to the point of saying, with regard to Stark and kickback and remuneration, it identified what Stark was, it identified what the kickback law was, it gave the citation for it, and it talked about specifically what remuneration was, so that there's no question. I actually showed it to other people in my office because I said I've probably never seen sort of a layperson give this great description of what remuneration is, because no employee at that particular company can say that they don't know what this remuneration looks like. So I think the more specific you are, the better equipped your employees are, and the more well-versed they are based on what you've told them. The other reason to do this that I didn't bring up before is that if you get hit with a qui tam, a subpoena, a government investigation, to the extent that your policies and procedures and the guidance that you've given your boots on the ground, your employees, to the extent that that's better detailed and really accurate, will only help you look like the company that hopefully you are. There are certainly times when companies make mistakes, make errors. It looks a lot more credible if you're able to say, we trained our employees, we told them not to take gifts from, physicians or anybody else, but they did it anyway. Well, that looks a lot better than when I ask you for, what did you tell your employees, and you say, I told them to follow the law.
Is there a website, email address, or phone number that people in the audience can call, email, or write in to report a complaint for a possible violation? Sure.
The OIG's hotline, which I will have to unfortunately look up, I can't remember off the top of my head what the number is, but I think we can share that in a little bit. But that is the best way to call us. That number is staffed. And when I tell you, I talk to the people who staff the number, they forward the calls to me sometimes. This is not a vacuum that your complaint is going to. It will be sent to the region where it's coming from, and it will be heard. So you should feel comfortable. This is one time when I can say government bureaucracy. It really does work. We really do talk to those people. And I have cases that have come strictly from complaints that have been received on the hotline. So we take it very seriously.
What if a marketer owns their own AFC home or adult daycare center? Is it okay to employ them as a liaison because of their involvement in the community?
If they own their own adult care center and they're a marketer for a different company, I don't know that that's necessarily an issue, that they may have a unique relationship by having this adult care center. But again, if there's no remuneration flowing back and forth and nothing sort of shady going on about that relationship, you're clearly hiring that person for their relationship to the community. If that's the reason for doing it, I don't necessarily think that that's an issue. Could it cause a red flag from your competitors? Certainly.
When OIG conducts an investigation, does OIG contact the agency first? If in connection to this question, there's been info that calls are received from OIG, but phone numbers provided are questionable.
Oh, I think that the question is if you're getting a call from somebody who purports to be the OIG.
But it's got it. Okay.
I've been at the OIG for 8 years, and I've never experienced cold calling anybody as part of an investigation. I hate to say we operate in the cover of night, but we kind of do. Normally the investigation's going on and you don't know that that investigation is happening. You will know when you receive the subpoena. That's usually the tipping point. There are times when an investigation can occur, though, and maybe in the course of that investigation, we're talking to a former employee and the employee says, you know, you should call this person, they used to work there too, or they still work there, but they'll be willing to talk to you. And we may or may not call that person, probably not if they're actually still working there. But there are times when that can come up, and so you could get a call from an OIG agent who's saying, I got your name from another former employee, want to talk to you about what's going on at a particular entity. I would be hesitant to say, though, that OIG just sort of cold calls people in an investigation. I mean, that is not typically our MO. Doesn't mean that it couldn't happen, but I would be suspicious of that.
Does the anti-kickback law only apply to federally funded services like Medicare and Medicaid, and not to private and self-pay agencies?
I think with private and self-pay, I can't profess to know the law really well in terms of what's permitted there. I think that there are still, the kickback statute is actually a criminal statute. I think in the private side, there can still be an argument for a kickback going on. I don't really know that those are heavily prosecuted. I'm just not familiar enough with that area of law to know, but I would say it could still be an issue, sure. Because again, that's something that typically paying sort of what we call, forget healthcare or anything else, a kickback is a problem.
Can you give a bonus to your W-2 employees for referrals?
I would question doing that. I think if you're paying people, if there's a bonus structure in place for getting referrals, again, it starts to color the reason why those referrals are happening, which is the money versus necessarily the care. So I would be hesitant to do that.
Can HMOs or PPOs direct their PCPs to refer to a certain hospice?
I don't know the answer to that.
What happens when a physician tells a patient that they will not follow them if they choose another hospice than the one that the physician recommends?
I would question what the relationship is that the physician has with that particular hospice or entity. And if I were the patient, I would say, you are depriving me of my right to choose. I'm supposed to be apprised of all my choices. And you telling me that you're basically going to get rid of me if I go to this, if I choose something that you don't want, flies right in the face of that. That's a hotline complaint to me.
Would OIG consider providing sample standards of conduct to various sectors of the healthcare industry, similar to the different compliance guidance documents? It would be very helpful.
I think we've toyed with that idea over time, but the problem is that, as you can imagine, we see so many different types of providers, and we're very cautious about, once we come out on a platform, that's the end of it. Like that is what the OIG has owned, and we have said this is the absolute right way to do something, and if you do it any other way, it's wrong. I think the problem with doing that, it sounds ideal, but it's very difficult for us to figure out necessarily what those are and figure out whether all of them are required. If we say them, like I said, people take them like they're the truth from the Bible. They will feel like they have to employ all of those standards and practices, even if some of them don't necessarily make sense for a particular provider. So I don't think OIG's, at least to my knowledge, not in the near future, comfortable with doing that because of the concern that we're putting providers in a box and ourselves in a box when this is somewhat of a fluid area. I would say that to the extent we have guidance that we are comfortable with, it shows up on our website and it's easily accessible, and that's probably as comfortable as we're going to get with giving that advice.
Here's a question regarding hospice. If providing or having legacy items or remember me items provided to hospice families, would that be seen as inducement? The purpose would really be for grief work and support the family of the deceased.
I think it would depend on what those are and what the reason why you're using that. I mean, the reason on paper is that you're seeking to assist these people with a loss. I think that a competitor may draw a different conclusion, that you want that family to walk away and tell another family that this is the best company to go to. If you're giving them, I don't know, some cupcakes or something, is that an issue versus giving them some sporting tickets? I believe that part of it, and part of what we're seeking to understand, is what is it that you're giving? It's the what. It's all, this is all totally the dirt is in the details here, that you got to get into what it actually is that you're giving and your reason why you're giving it.
This sort of goes along the same. Would offering beneficiaries holiday meals be seen as an inducement if they are just provided to those identified as financially needy?
I think we talk about this a little bit on the website, where we say you can offer something like meals, but there are rules that go along with that. One, the amount, where they can be offered, and the setting in which they're offered, meaning that if they were offered in say, a particular community office or something like that, where it's accessible by everyone in the community, not just a specifically identifiable group of people that could potentially be patients, we would have less of an issue with it. I think you have to be careful when any provider designates something going to a category of bennies with need, because we've seen a trend that a lot of organizations will say, well, we're doing this to help these people who are financially challenged. That's great, but one, I've seen situations where the organization said that these people were financially challenged. They absolutely were not financially challenged. And so I think it begs some questions about what it is you're doing and where you're doing it. If it's publicly accessible to everyone, and again, you're not targeting a particular group of people, like an open space in a community organization's gathering room, I think it's probably less problematic. But I would look carefully at what the internet, what we say about those kinds of gifts, if you want to call them that.
Can a medical director bill for hospice physician visits under their own NPI number instead of a hospice billing for those services?
I believe that there's a split in the way that the billing would occur. Like, I believe the physician gets a portion of it. There's reimbursement for the physician, but also for the hospice. But I'm not positive about how the billing breaks down for that. But I wouldn't be surprised if there's not a professional component of that hospice care. And I should add to that. I don't know whether, in most situations, I believe that the hospice would bill for it and would carve out. They would receive documentation from the physician saying that you could bill for their services, and then they would get reimbursed later. But I don't necessarily think that that's the only way that could be structured.
If a company owns a home health agency and a hospice agency, can a patient be transferred to their hospice agency without any issues, or would the home health agency have to offer more than their own hospice?
That's a great question. I don't know. I'd like to follow up about that, definitely. Actually.
We'll be sending out a link at the first week of January.
Yeah.
So we'll try to answer some of these questions.
Sure.
If someone has been placed on the LEIE and is excluded from participating in MCR and MCD programs, can they go out and open a home health agency under a spouse's name and make referral to the agency?
More than likely, no, but there are, and again, our website has some guidance about what happens when you're an excluded individual. You receive notice when you're excluded about what you can and cannot do. As you can imagine, we see a number of cases like this where people are excluded and realize they can't bill the federal healthcare programs and get a straw woman or man to set up a company, and they're sort of behind the scenes. You're prohibited from doing that. And the individual, if they're your spouse, and there's a child, I think it even goes to grandparent and stepchildren, are not supposed to associate or bill the federal healthcare programs if they have this relationship with the excluded individual. In theory and in practice, the excluded person is already excluded and they're in a bad situation. That is something that puts the person who actually has the billing number at great risk. Because at any time, I have cases like this now, where I'm looking at emails from the excluded individual to their brother because they're running the company and they're billing the federal healthcare programs, and the brother is going to be excluded as well. So not worth it, more than likely.
If we find that an ex-employee was on the LEIE list, is the home health agency required to self-report?
Required, I would say you're required, because which people are always shocked by this, but we find out about excluded individuals in sort of weird ways sometimes. We actually do our own information gathering. When people seek to get reinstated, they will often there's a question on their application which asks them if they have worked anywhere, where have they worked since their period of exclusion. Surprisingly, I'll say shockingly, they're usually very honest, and they'll say, oh, I worked at these 10 hospitals and or nursing homes during my 10-year period of exclusion. Well, of course, for me, that's open season, because that means that I'm investigating all 10 of those organizations, because they should have found out that that person was on the LEIE. So in my estimation, if I were to look back through an audit or any other way and find out that someone was excluded, I would absolutely tell the government, because I sort of think that we will find out about it one way or another. And I know you never welcome a phone call from me at any time, but 4 years after the fact, you probably really don't want me to call and say, did you employ this person? We have tax records, et cetera. I would encourage every provider to self-report, because like I said, we're probably going to find out about it through that provider or through someone else. We get phone calls from people who say, I don't like the person who sits in the cubicle next to me, and I looked them up on the LEIE, and they're on there, and they're still working here. So,
can a home health agency hire someone who works part-time at a physician's office?
I think that they could. I think, again, it's not about what they do. It's about whether if there's any remuneration going back and forth between the parties. Are they hiring that person just to get a lead into that physician? Are they doing it so that they can get that person to then say to the physician, hey, we'll give you X amount of dollars if you send business over here? Just, could you hire somebody who works at lots of different places? You could.
Good to know. A physician can bill care plan oversight for certifications and recertifications and 30 minutes monthly for specified areas. Is this correct?
I don't know about the 30 minutes, and I'm not positive about the certification, recertification. That could potentially be absorbed in another area that you're billing. So I'm hesitant I definitely don't know that definitively. That's a CMS question about what their billing structure is like. I don't know about that.
Can a patient currently under a home health service switch to another agency if unsatisfied with the current service?
Of course. Patients have the right to choose their care wherever they want to go.
So I think that is it. Oh, I'm sorry. One more. What are some of the red flags for OIG as pertaining to home health and hospice?
I think red flags are the referral sources, the referral patterns that I talked about before. I think for home health, again, the categories I talked about, the referral sources, checking the LEIE, making sure that your staff is not full of a bunch of people or even one person that's been excluded. For hospice and for home health, I think billing irregularities, which I will admit you may not know are billing irregularities, but you've got to find out and dig into the way that your business is run to really see if there are billing irregularities. That those are all red flags. When I talk about the data and how we can receive the data, I wish I could show it to you, because I think it's dramatic for me because we couldn't get this data a few years ago. I can literally enter a query of almost any sort for any Benny, for any particular provider, to get real-time information about if we see a trend going on. I can find that trend. It doesn't mean that the trend isn't always defensible, that there's not a reason why that trend is occurring. But the point is that if I know about it, I can seek the information and get an answer pretty quickly. So you identifying your own trends is really important, because that's going to be your self-identification of problems within an organization is really your best defense.
Well, Nancy, thank you. This has been very informative.
Thank you.
I appreciate you taking the time to be with
it
us
too.
today and the audience out there.
Thank you.